Hello, good evening, and welcome to BYJU'S Exam Prep. Welcome to Target Prelims 2023, and today is lecture 4 and the last lecture on Indian polity. Tomorrow onwards, we will have discussions on environment and ecology, then international relations, so on and so forth. And since today is the last class on Indian polity, please do let me know after the session is over whether these sessions on Indian polity were of some help to you. And if they were indeed helpful, please do not forget to press the like button and let me know in the comment section. And today we'll discuss lots and lots of MCQs. So let's get started and look at question number 1. Which of the following statements is or are correct regarding a curative petition? Why curative petition is in the news? Something happened in 1984, Bhopal gas tragedy. And then one organization which was responsible for this, one company, Union Carbide, it was imposed a fine. Basically, compensation had to be provided to the victims of the gas tragedy. And then in the year 2010, a curative petition was filed by the central government before the Supreme Court, basically asking to revise, increase, and enhance the compensation provided to the victims. And in 2023, this year, this curative petition was rejected by the Supreme Court. So this topic of curative petition can be important for your examination. Let's look at some of the details. Article 137 of the Constitution of India, it provides power to the Supreme Court that Supreme Court can review its own judgment. And for that, a petition is filed. That petition is known as a review petition. So once the verdict is given by the Supreme Court, then to review that verdict of the Supreme Court, a petition can be filed, which is known as the review petition. What are the conditions? This review petition should be filed within 30 days of the petition which was decided by the Supreme Court. Once the final judgment was given, within 30 days, review petition should be filed. And it must satisfy two conditions. Number one, it must point out an error in judgment. So the petitioner will have to point out an error in the judgment which was given by the Honorable Court. Second, new facts have emerged in the case. If these two conditions are satisfied, then the review petition is accepted. If these conditions are not satisfied, then the review petition is dismissed. But something happened in the Sabarimala case. The Supreme Court, headed by the then Chief Justice of India, Justice Ranjan Gogoi, did something unprecedented, which did not happen previously. Instead of rejecting or accepting the Sabarimala review petition, the Chief Justice of India kept the review petition pending. So that was an exception. But the point is, after review petition is dismissed, the case is over. Then in the year 2002, something else happened. Supreme Court said finality of justice is important. That means there has to come a stage where the justice would be over, the case would be over. But the Supreme Court said finality of justice is very important, but at the same time, it cannot be at the cost of justice. So we can accept another review petition, and that another review petition is known as curative petition. And this curative petition, if I am filing this curative petition, I have to submit some of the important facts regarding my case. Some conditions have to be satisfied. For example, I have to convince the judiciary that your judgment has gravely affected me, that there was a bias in the minds of the judges. There is a bias in the judgment which was delivered to me. All these details I have to submit, and then I have to get it ratified by a senior advocate. That is why we discussed conditions regarding the designation of the senior advocate yesterday in the session as well. So review petition under Article 137, which means the Supreme Court can accept another petition after it has given the final verdict within 30 days of the judgment, and that is known as review petition. And something happened in 2000 and 2002. The Supreme Court said we will accept another review petition, and that another review petition is known as a curative petition. And once I submit this curative petition, I have to get it ratified by a senior advocate. Then those judges who gave the judgment will accept this curative petition, and ultimately then the court will decide whether we have to accept this or reject this. But the point is, which of the following statements is or are correct regarding a curative petition? The court said in Rupa Kumar Hurra versus Ashok Kumar Hurra, in this case, the Supreme Court said we are accepting and we are innovating curative petition to ensure that there is no miscarriage of justice, to ensure and to prevent abuse of power. And all these curative petitions are decided based on the principles laid down by the Supreme Court in this landmark Hurra versus Hurra judgment. So statement 3 is also correct. But the power of curative petition flows from Article 142. This is incorrect. Why? Because it flows from Article 137 of the Constitution, which gives power to the Supreme Court to review its own judgment. The first review petition should be filed within 30 days of the judgment. Then ideally within 30 days, you can file the curative petition. But the court can accept a curative petition even if it is filed after 30 days. But for that, you have to convince the judiciary what led to the delay in filing this review or curative petition. So which of the above statements is or are correct? B, 1, 2, 3 is the right answer. Clear? Done. Let's look at question number 2. Which of the following statements regarding Punchi Commission is or are correct? Why Punchi Commission is in the news? Because there is a tussle between the governor of Kerala and the state government of Kerala, primarily regarding the appointment of vice chancellors of state universities. And for that, you need to understand what are the UGC guidelines. UGC guidelines regarding the appointment of vice chancellors, and these guidelines were released by University Grants Commission in 2013. According to UGC guidelines, the vice chancellor shall be appointed by the governor. Why? Because the governor is the chancellor of the state universities. And the governor will appoint a vice chancellor, but then what is the process for that? The process is that there should be a search committee constituted. For example, there is a state university A, and for that we need to appoint a vice chancellor. UGC guidelines say that a person to be appointed as a vice chancellor of a state university, he should have a minimum 10 years experience as a professor of a university or as a researcher in a research institute. Then this search committee should be constituted, and this search committee will finalize 3 to 5 names. This search committee will consist of academicians who are experts in their field, but they should have no connection with this university or the colleges under this university. When this search committee will be constituted, then this search committee will invite applications for the post of the vice chancellor and will zero in on 3 to 5 names. Those who have experience of more than 10 years in research institutes or in academic field, and then 1 out of these 3 to 5 names will be appointed by the chancellor, by the governor of that state. These are the UGC guidelines. And we saw some controversy where the search committee selected only 1 name, and that 1 name was appointed as the vice chancellor of a university in Kerala. Matter ultimately went to the court. The Supreme Court struck down this appointment, saying you have violated the UGC guidelines. But something had happened. Punchi Commission, which was set up by the government in 2007 on center-state relations, it submitted its report in 2010. It was headed by the former Chief Justice of India, Justice Madan Mohan Punchi. And Justice Madan Mohan Punchi in its report had said that this convention that we are following, where the governor is the chancellor of state universities, this convention must come to an end. That is why there are various states, for example, Kerala, for example, West Bengal, and they have tried to remove governor of a state as the chancellor of state universities. So which of the following statements regarding Punchi Commission is or are correct? Number 1, it recommended that the convention of appointing governors as chancellors must come to an end. Correct. Chancellors of, to make it even clear, chancellors of state universities. public universities. Number 2, it recommended that the right of a governor to sanction the prosecution of ministers, even against the advice of the government, should continue. Even if the state government is advising the governor, don't sanction prosecution for a minister who is indulging in corruption or any crime, this should not be binding on the governor. Punchi Commission said the governor should have the right to sanction the prosecution of ministers, even against the advice of the state government, and this should continue. It recommended that the person to be considered for the post of a governor should stay away from active politics, even at the local level, for at least 2 years prior to his appointment as a governor. This statement is also correct. So which of the above statements are correct? D, all of the above is the right answer. Clear? Very good. Let's look at another question. Which of the following statements is or are correct? Number 1, the Constitution of India does not explicitly mention the option of delivering dissenting judgments by the judges of the Supreme Court. Number 2, Parliament has the power to expand Supreme Court's jurisdiction and powers. Which of the above statements is or are correct? We saw when the Supreme Court expanded the scope of Article 19 and 21, Justice Nagaratna gave a dissenting judgment. We saw on demonetization also, there was a dissenting judgment. We saw on economically weaker sections of the society judgment, there was also a dissenting judgment. So this year has been the year of dissenting judgments. Is the concept of dissenting judgment mentioned in the Constitution? If you look at Article 145 of the Constitution, it talks about that, let's say there are 5 judges who are hearing a case. What will be the final judgment of this court? Something which is decided by the majority. That means the judgment of the Supreme Court will be something which is the opinion of the majority of the judges. That's number 1. Number 2, the same Article 145 also allows a judge to give a dissenting judgment. This judge may not agree with the judgment given by the majority judges. So minority judgment, which is also known as the dissenting judgment, this is something which is explicitly mentioned in Article 145 of the Constitution. So Constitution of India does not explicitly mention the option of delivering dissenting judgments by the judges of the Supreme Court. This is incorrect because Constitution explicitly provides for it under Article 145 of the Constitution. And under Article 140, what Constitution says? Constitution gives power to the Parliament. That Parliament, what you can do, you can confer additional powers on the Supreme Court. You can increase the jurisdiction of the Supreme Court, provided you are not interfering or limiting the existing jurisdiction, the existing powers which are given to the Supreme Court. So who has the power to expand the jurisdiction, conferring more powers on the Supreme Court? That power is available with the Parliament. So which of the above statements is or are correct? B, only 2 is the right answer. Clear? Let's look at question number 4. Which of the following statements is or are correct regarding electoral bond scheme? Electoral bonds, they were created, the scheme was created during the budget speech of 2017 when Mr. Arun Jaitley was the finance minister. And this electoral bond scheme got implemented from 2018. The purpose was to ensure that clean money is donated to the political parties. Because do political parties need money? Yes. To campaign in the elections, to communicate their ideology and their policies, the political party needs money. But the political party should be donated clean money, which is known as accounted money. And for that, a scheme was launched known as the electoral bond scheme, under which if you are a donor and if you want to donate money to a political party, what you have to do, you have to approach the State Bank of India. And what you have to do, you have to buy an electoral bond. 1,000 rupee, 10,000 rupee, 1 lakh rupee, 10 lakh rupee, 1 crore rupee. You can buy as many electoral bonds as possible. But you can buy these electoral bonds only through check or through digital transaction, for example, RTGS, NEFT, through demand draft, but no cash would be used to buy these electoral bonds. And then the political party will have 15 days to encash this money. And these electoral bonds are bearer instruments, which ultimately means that all these donations will be anonymous. You, me, nobody will get to know who is donating money to which political party. But you would have all the information about the electoral bonds. But something has happened in the year 2022. What has happened? Previously, the rules would say that every year, this window to purchase, to buy these electoral bonds would be opened by the central government. When? In January, in April, in July, in October. 4 times in a particular year, we will open the window to buy these electoral bonds. But if today, for example, in 2024, it is the period of Lok Sabha elections, apart from these 4 months, additional 30 days will be provided for the individuals or organizations to buy these electoral bonds. That means apart from January, April, July, October, first month of every quarter, apart from these months, additionally 30 days will be provided when we have a Lok Sabha election, which is in 2019, 2024, later 2029. Additional 30 days window will be provided, but only when we have a Lok Sabha election. But in 2022, the central government said, not only during Lok Sabha, if in a particular year we have legislative assembly elections, during this period of legislative assembly elections, additional 15 days. That means apart from January, April, July, and October, apart from these 4 months, additional 15 days will be provided when this window to purchase these electoral bonds would be opened. And this was the time when we had legislative assembly elections planned, scheduled for the state of Gujarat, the state of Himachal Pradesh. That is why electoral bonds become important for your examination. In fact, this matter is pending before the Supreme Court. The matter is before the court where the petitioners have challenged the constitutional validity of electoral bonds. Let's look at the question. Which of the following statements is or are correct regarding the electoral bond scheme? The scheme was introduced via the Finance Act of 2017, which is the budget. Correct. The bonds under the scheme shall be available for purchase for a period of 10 days each in the months of January, April, July, and October, as may be specified by the central government. Correct. An additional period of 30 days shall be specified by the central government only in the year of general election to the House of People, which is Lok Sabha. But not only during Lok Sabha election, also during Legislative Assembly election for a period of 15 days. This change has been made in 2022, which renders statement 3 as incorrect. Which of the above statements are correct? B. Only 1 and 2 is the right answer. Clear? Great. Question number 5. Which of the following was ruled by the Supreme Court in the Anup Baranwal versus Union of India 2023 judgment? And you should know that this Anup Baranwal judgment is related to the appointment of election commissioners to the Election Commission of India. Clear? Let's look at the statement. And I want you to answer this question for me. I don't know the answer to this question, so can you please help me in answering this question? The election commissioners shall be appointed by the President after consultation with a committee consisting of the Prime Minister, Chief Justice of India, and the leader of the opposition or the leader of the single largest party in Lok Sabha. The salaries and allowances of the CEC and EC shall be charged on the Consolidated Fund of India. Right to vote is a constitutional right. The election commissioners shall be removed in the same manner as the Chief Election Commissioner. Right to vote is a constitutional right. That is 100% correct. But I'm only asking you whether this was said by the Supreme Court in Anu Baranwal judgment or not. I will give you 1 minute. Please let me know what is the answer to this question, because I don't know the answer. Only 3 statements are correct, 2 statements are correct, 1 statement is correct, all the 4 statements are correct. Okay. 10 seconds more. The election commissioners shall be appointed by the President after consultation with a committee consisting of Prime Minister, Chief Justice and Leader of Opposition or single largest party in Lok Sabha. This is correct, yes. But I should add, till a law is passed by the Parliament. Please listen to me carefully. It is not that always, forever, the Chief Election Commissioner and the election commissioners shall be appointed by the President after consulting this committee. No, this is only a time gap arrangement till the time Parliament will enact a law and fix the appointment process. Number 1. Number 2, the salaries and allowances of the CEC and EC shall be charged on the Consolidated Fund of India. This is incorrect. Although it is true that the salary of the CEC and election commissioners, they are not charged on the Consolidated Fund of India. But the Supreme Court, it basically requested the Parliament that, dear Parliament, you should consider that the salaries of the CEC and election commissioners should also be charged on the Consolidated Fund of India, because right now they don't have financial independence. But this was not ruled by the Supreme Court in this Anu Baranwal judgment. It was basically requested by the Supreme Court, requesting the Parliament that you should do this. But it was not ruled. It is not binding. Right to vote is a constitutional right. Yes, it was once again reiterated by the Supreme Court in Anu Baranwal judgment that right to vote is a constitutional right under Article 326 of the Constitution. In fact, one judge on this bench, he said that right to vote is a fundamental right. Although it's a minority view, that is why we can't say right to vote is a fundamental right. But Supreme Court in this judgment again reiterated that right to vote is a constitutional right. The election commissioner shall be removed in the same manner as the chief election commissioner. Incorrect. Why? Because again, the Supreme Court requested the Parliament, put the ball in the court of the Parliament, that what you should do ideally, you should also provide the same security to the election commissioners as you have provided, as the Constitution has provided to the Chief Election Commissioner. Because how is the Chief Election Commissioner removed? The Chief Election Commissioner is removed by the President on the basis of the resolution passed by both houses of the Parliament. And the Chief Election Commissioner is removed in the same manner as the judge of the Supreme Court is removed on the same grounds, like grounds, as the judge of the Supreme Court is removed. So if the judge of the Supreme Court is removed by President based on the resolution passed by the Parliament on the grounds of proved misbehavior and incapacity, in the similar fashion, the Chief Election Commissioner is also removed. But how is the Election Commissioner removed? Election Commissioner is removed by the President only on the recommendation of the Chief Election Commissioner. So on the recommendation of the Chief Election Commissioner, election commissioners can be removed by the President, which means election commissioners, they do not have security of tenure. And the Supreme Court in this judgment requested the Parliament that you should provide the same level of security as the Constitution is provided to the Chief Election Commissioner. The same security you should provide to the election commissioners. But it was only a request, which basically means, can Supreme Court, another statement for you, and you have to answer me either in yes or no. Can Supreme Court issue a writ of mandamus to the Parliament? Can Supreme Court basically issue the writ of mandamus telling the Parliament that we command that you enact such a law, that we command that you make such provisions to the Constitution, that we command that you make such and such provisions to the laws that you have been passing. No, this cannot happen. So what is the correct answer here? Only two statements are correct. B is the right answer. Clear? Done. Question number 6. Which of the following is correct regarding C Vigil? It is a mobile application for citizens to report model code of conduct and expenditure violations during the elections. It is a mobile application for citizens to alert the law enforcement authorities regarding a suspicious unattended vehicle bag that may trigger a terror attack. It's a mobile application for citizens to report to authorities cases of food adulteration, hoarding, and illegal profiteering. None of the above. What is the number of election commissioners? Up to 4 election commissioners can be appointed by the president. Although the Constitution said the election commission shall consist of chief election commissioner and as many election commissioners as may be appointed by the president. Then in the year 1991, a law was passed. This law was amended in 1993, known as Election Commissioners, Conditions of Service Act 1991, according to which the president can appoint not more than 4 election commissioners. It is a mobile application for citizens to report model code of conduct and expenditure violations during the elections. Why C Vigil becomes important for your exam? Because this app was started during 2018 Karnataka elections for the first time. And today it is 2023, another year of Karnataka elections. On May 10th or May 7th, elections would be conducted in Karnataka, then results would be declared 3 days later. So if something was started by Election Commission of India in 2018 Karnataka elections this year as well, C Vigil becomes important for your examination. And according to this C Vigil, for example, you open the app, you take the photo or the video, but you cannot use the photo and the videos that are already stored in your gallery. You can't use pre-recorded or previously used photographs and upload it on the C Vigil application. That you can't do. You have to capture the moments live. And at the same time, one more way in which we can prevent the misuse of this app is that this app would be functional only in the geographical area where elections are being held. According to Election Commission of India, during Karnataka elections in 2018, then in West Bengal elections, this experiment of C Vigil was not successful. But later on in subsequent elections, even in 2019 Lok Sabha elections, this app has performed spectacularly well, and it has led to a large number of convictions when alert citizens have uploaded content, videos and photographs of the violation of model code of conduct, of the violation of expenditure by the contesting candidates. That is why C Vigil becomes important for your examination. So A is the right answer. Question number 7. Which of the following statements is or are correct? The remote electronic voting machine, which can handle up to 72 constituencies, is being used for the first time in Karnataka Assembly elections of 2023. The voter verifiable paper audit trail (VVPAT) was introduced in the Noxon Assembly constituency of Nagaland in 2013. The Election Commission of India recently also tried to portray and tried to involve all the political parties, so that Election Commission of India wanted to give them a demonstration how we can use a remote electronic voting machine whose prototype was developed by IIT Madras and other institutes. And that remote EVM would handle up to 72 constituencies. you would know that voting percentage in India is less. And this is mostly because of those who are known as circular migrants. I may be from Bihar, but I'm working in Karnataka. I cannot go back to Bihar when it is the assembly elections in Bihar or Lok Sabha elections. And that is why I can't cast vote in Bihar in my constituency. This remote EVM could have ensured that without me traveling to Bihar during the assembly elections or Lok Sabha elections, in Karnataka itself, I can vote for the candidate of my constituency. And this remote EVM would handle up to 72 constituencies. But ultimately what happened? Political parties, opposition political parties, the BJP was in support, opposition political parties said, we do not have faith in your EVM. So forget about remote electronic voting machine, which will allow migrants to vote remotely. We do not have faith and trust in your existing EVMs. So first enhance the transparency of your existing EVMs. Then we can talk about remote EVMs. So remote EVMs are not being used right now and will not be used in the upcoming Karnataka assembly elections. Number one. Number two, the voter verifiable paper audit trail was introduced in the Noksen Assembly constituency of Nagaland in 2013. This is correct. So which of the above statements is or are correct? So B is the right answer. VVPAT. What is this VVPAT basically? It's like a printer attached to your electronic voting machine. Clear? This printer, what it would do, as soon as you press the button on the electronic voting machine, a display would tell you what is the serial number of your vote, what is the name of the candidate you're voting for, and what is the symbol of that political party that you have voted for. This information would be displayed for 7 seconds and then it will be cut. And this paper will drop in the VVPAT box. After the election is over, when the counting of the votes will start, then these VVPAT slips will be matched with the EVM number. If I give you a statement, all VVPAT slips are to be matched with the EVMs, is the statement correct or incorrect? Incorrect? Absolutely incorrect. So what you have to do, the Election Commission will take a look at the constituency, will randomly choose 5 polling stations, 5 polling booths from that constituency, will take the printed VVPAT slips and will match the EVMs. That is why there is a demand from various experts as well as former chief election commissioners that we should go for 100% verification of VVPAT slips with the electronic voting machines. So what is the correct answer? B is the right answer. Let's look at question number 8. Which of the following statements is or are correct regarding the Official Secrets Act OSA? Why this is in the news? Because this is the 100th anniversary of the enactment of the Official Secrets Act. 1923 it was enacted and it was retained after the commencement of the Constitution, after the independence of India. That is why this topic becomes important for your examination. This Official Secrets Act, basically it is applicable to citizens as well as government servants. It's not only that government servants who have access to information, they cannot share this information with somebody. Even the citizens cannot share the secret information with somebody. So this act, number 1, was enacted in 1923. Number 2, it is applicable on citizens as well as the government servants. And this is a law which is basically tackling spying, sedition, and other acts which threaten the integrity of the nation. And what this law basically does, it prohibits what? Sharing of secret information. For example, a journalist. Even if the journalist is writing a story, but this story deals with something which is an official secret, and this story may help an enemy state. If I'm the journalist, my intention is not to help the enemy state, but the information that I am giving, which is an official secret, this information will happen or may help an enemy state. I can still be booked under the Official Secrets Act. And the punishment is up to 14 years. But the bigger problem is that this law does not define what is a secret. This law does not define what is an official secret. It basically means I cannot use the police uniform. I cannot use the army uniform if I'm not an army man. I cannot threaten or interfere with the operations of an army in a prohibited area, in a restricted area. All these are part of the Official Secrets Act. The act was, which of the following statements is or are correct regarding the Official Secrets Act? Number one, the act was enacted in 1923, correct? The act does not define secret and official secrets. This is also correct. The act makes it punishable to share information that may help an enemy state. Although it's not your intention to help an enemy state, but the information that you have shared is helping. For example, a chart, for example, a sketch, for example, a photograph, for example, the map of a prohibited area. If this you're revealing and it is going to help an enemy state, you will be booked under Official Secrets Act. This is also correct. The Second Administrative Reforms Commission suggested Official Secrets Act should be retained. This is incorrect. Why? Because the Second Administrative Reforms Commission basically said that this Official Secrets Act should be substituted with a chapter in the National Security Act. So Second Administrative Reforms Commission was not in favor of retaining the Official Secrets Act because it goes against transparency. On one hand, you are providing right to information as a statutory right, and on the other hand, you are saying that secrets which are not defined cannot be revealed. So 1, 2, 3B is the right answer. Very good. Let's look at question number 9. Which of the following is or are advantages of a national political party? Recently, what the Election Commission has done, it has removed 3 political parties from the list of national political parties. One such political party was CPI, not CPIM. CPIM is still a national political party. CPI, Communist Party of India, is no longer a national political party, nor is Didi's Trinamool Congress, nor is Sharad Pawar's Nationalist Congress Party. These 3 political parties have been removed from the list of national political parties. Now, how many national political parties do we have? 6. BJP, Indian National Congress, Communist Party of India Marxist, Benji's Bahujan Samajwadi Party, then we have National People's Party, which is the first political party from Northeast. In the year 2019, it was given the status of a national political party. And the last political party, Aam Aadmi Party, was given the status of a national political party. But what are the advantages of a national political party? Advantages, number one, you are given land at subsidized rates at prominent locations, sometimes free as well, for the construction of a mega headquarter of your political party. You get free airtime on Doordarshan and All India Radio to publicize your candidates or your manifesto, to campaign for the elections. You are given 2 copies of electoral rolls as well. But most important, two of the things are most important. One, for example, this is a constituency, and there are 20 candidates contesting election from this constituency. What if just before polling, one candidate dies? What will happen to the election? Will this election continue or not? There are 20 candidates, I'll repeat, there are 20 candidates contesting the election. Out of these 20 candidates, one candidate dies. What will happen to the election in this constituency? Will it continue or will it not? If a candidate belonging to a registered political party dies, nothing will happen to the election, election continues. If a candidate who is an independent candidate dies, nothing will happen to the election, election continues. But if a candidate belonging to a recognized political party dies, because all political parties, if they want benefit from the Election Commission of India, they have to register with the Election Commission of India. But over a period of time, some of these registered political parties are recognized by the Election Commission, recognized as either the state political party or national political party. So in this constituency, if the candidate dies before the election, we have to see who is this candidate who has died. If this candidate belongs to a recognized state or national political party, election will not continue. Election will be countermanded. The political party will be asked to set up another candidate and then election will take place. That is the benefit of a recognized political party. And national political party has another benefit. What it gets 40 star campaigners. And what are these star campaigners? For example, every candidate contesting the election has to spend an amount of money which is within the limit. For example, if it's a Lok Sabha constituency, I cannot spend more than 70 lakh rupees for my election expenses. But what if I bring in Mr. Modi to campaign for me? What if I bring in Mr. Amit Shah to campaign for me? The political parties before the elections or during the election campaigning, they have to submit a list before the Election Commission of India known as star campaigners. And whatever money is being spent on these star campaigners, their food, their lodging, their travel, those expenses will not be added to the expenses of the candidate contesting that election. And how many star campaigners can a registered political party have? 20. So registered political party can have only 20 star campaigners, but a recognized political party can have 40 star campaigners. But listen to me carefully. If the question would have said, which of the following are the exclusive advantages of a national political party, then the statement number 1 is incorrect. Why? Because this is not the exclusive privilege of a national political party. Even a recognized state political party can have up to 40 star campaigners campaigning in the elections. But what are the advantages of a national political party? Number 1, a national party can engage 40 star campaigners, correct? A party with a national status gets land from the government to build its headquarters, correct? Its candidates get free coverage on Doordarshan and All India Radio during elections, correct? So D, all of the above, is the right answer. Okay, criteria for the removal of the national political party. Let's look at the condition. And I'll tell you, I don't know the answer to this question. So once again, you will have to help me in finding the right answer to this question. A political party shall be eligible to be recognized as a national political party if any of the following conditions is fulfilled. Number 1, the party is recognized as a state party in at least 4 states. Let me know, I don't know. In the last Lok Sabha elections, the party has won at least 2% of the Lok Sabha seats from not less than 4 states. Criteria 3, the candidates set up by the party in the last Lok Sabha or state assembly elections have scored at least 6% of the valid votes in at least 4 states and have also returned 4 candidates to Lok Sabha from any state or states. Let me know what is the right answer. If it was too simple, I would not have asked. So I've confused you because now I got to know what is the answer. Okay. The party is recognized as a state party in at least 4 states. This is correct because Aam Aadmi Party was registered as a state political party in Delhi, in Punjab, in Gujarat, in Goa, and ultimately became a national political party. In the last Lok Sabha election, the party has won at least 2% of the Lok Sabha seats from not less than 3 states. Let's say total seats are 543. What is 2% of 543? Close to 11 seats. 11 seats should have won by this political party. But what if you are winning these 11 seats only from one state? Then you are not a national political party. A national political party means your presence is at a national level, not only at a state level. But you should have won these 11 seats from at least 3 states, not 4, at least 3 states. That is why this statement is incorrect. The candidates set up by the party in the last Lok Sabha or state assembly elections have scored at least 6% of the valid votes in at least 4 states and have returned 4 candidates to Lok Sabha from any state or states. Because here the focus is on valid votes. You're getting 6% of the valid votes. This statement is correct. 1 and 3, B, is the right answer. Karishma Chauhan is right. Okay? Great. So please, in the examination, read the statements clearly. Question 11. In which of the following states was the delimitation exercise not carried out in 2002? What is this delimitation exercise? A redrawal of electoral boundaries, known as constituencies. So the idea is, as soon as the census exercise is carried out, which ideally is carried out after every 10 years, we will redraw the electoral boundaries of the entire country and see if there should be an increase in the number of seats. Delimitation was carried out after the census of 1951 in 1952. Delimitation was carried out after the census of 1961 in 1963. Delimitation was carried out after the census of 1971 in 1973. Then there was a pause. Why? Because the southern states protested. Southern states said, we have successfully implemented family planning programs. That is why our population has more or less stabilized. But look at the northern states. They have been unable to control the population. The population is exploding there. So if in the northern states, population will keep on increasing, and corresponding to that, you will be increasing the number of seats in the northern states, then there will come a time where the southern states will be at a disadvantage. They will lose their voice in the cacophony of the noises coming from the North India. That is how the constitution was amended, and constitution was amended to say that now no delimitation will be carried out till the census of 2001. And even if delimitation is carried out, seats will be frozen till the census after 2026. Because by the year 2026, we would have reached a stable population number. After 2026 census, we will increase the number of seats. But after 2001 census, since delimitation can be carried out, so delimitation can be carried out, but the number of seats will not increase. Number of seats will not increase, but delimitation can be carried out. And this delimitation was carried out in 2002. The final report was given in 2008. But sir, what is the difference? Delimitation cannot be carried out till the census after 2001, but no seats can be increased till 2026, till the next census after 2026. Then what was the point of carrying out delimitation exercise in 2002, whose final award was given in 2008? That was known as internal delimitation. Internal delimitation in the sense, for example, this is a state where we have 3 constituencies, A, B, C. In constituency A, we have 10 lakh voters. In constituency B, we have 50 lakh voters. In constituency C, we have 30 lakh voters. So that means in constituency A, 10 lakh people are represented by 1 MP. 50 lakh people are represented by 1. 30 lakh people are represented by 1. So one person, one vote has been violated. Delimitation was carried out in 2002 to ensure that if there are 90 lakh voters in this state, let's split it into 30 lakhs, 30 lakhs, 30 lakhs, so that at least within the state, one person, one vote will be implemented. We will not increase the number of seats, but we will carry out internal delimitation. And something else was the reason. There was second reason for carrying out delimitation in 2002. As the population of SCs and STs have increased, because we have to provide reservation in Lok Sabha and legislative assemblies to the members belonging to SC and ST community, their population has also increased. So corresponding to that, we have to increase the number of seats reserved for them. We will not increase the total number of seats. So if the total number of seats are 80, and previously the seats reserved for SCs and STs were 30, total number of seats will still remain 80. But the seats reserved for SCs and STs may be increased to 45. That was the reason why delimitation was carried out in 2002. And delimitation is ideally carried out by Delimitation Commission. And who is the member of this Delimitation Commission? One is the chairperson, who should be the former Supreme Court judge, Chief Election Commissioner, State Election Commissioners. They are part of this Delimitation Commission. And whatever award is given by Delimitation Commission, that cannot be challenged in any court of law. For example, delimitation exercise has now been completed for the Union Territory of Jammu and Kashmir. It didn't happen for Ladakh, it happened for Jammu and Kashmir. Final award was given. It cannot be challenged in any court of law. But sir, we read something. We read that this Delimitation Commission's award was challenged in the Supreme Court and Supreme Court rejected that petition. Then how can you say that the award of the Delimitation Commission cannot be challenged in any court of law? Listen to me carefully, there is a difference. You can challenge the constitution of Delimitation Commission. You may say that we don't need Delimitation Commission. You may say, why single out Jammu and Kashmir when in the rest of the country you cannot have delimitation, you cannot increase the number of seats till 2026. On this ground, you can challenge Delimitation Commission. But you cannot challenge the award of the Delimitation Commission. If the Delimitation Commission says that now 7 seats will be increased for the Jammu and Kashmir Legislative Assembly, 6 seats will go to Jammu, 1 seat will go to Kashmir. On this ground, you cannot challenge. You can challenge the very constitution of Delimitation Commission, but you cannot challenge the final award given by Delimitation Commission. That is why Delimitation Commission is in the news. But in the year 2002, when the delimitation exercise was carried out, the final award was given in 2008. There were some northeastern states which were kept out of delimitation exercise because of security risks. And which were these states? Assam, Arunachal, Manipur, Nagaland, 1, 2, 3, 4. A is the right answer. And at that time, listen to me carefully, very important statement. At that time, when these 4 states, northeastern states, were kept out of delimitation exercise because of the security risks, the president said, next time, when delimitation will be carried out in these 4 states, delimitation will not be carried out by the Delimitation Commission. Delimitation will be carried out by the Election Commission of India. And now delimitation exercise is being carried out where? In the state of Assam. And for that, let's look at another question. Question number 12. The Election Commission of India is carrying out the process of delimitation of assembly and parliamentary constituencies in Assam. Number of seats will not increase. Number of seats will remain the same, but internal delimitation, as happened in 2002, is going to happen in Assam. So this statement is correct. The process will be based on the census data from 2001. This is also correct. C, both is the right answer. There are some political parties, some activists who are saying if the census data of 2011 is available, why are you carrying out delimitation on the basis of the census data of 2001? But be that as it may, these are political noises. For your examination, both the statements are correct. C is the right answer. Any questions as of now? Clear? Okay. Before we continue, I will not continue till you press the like button. Let's say if we have, I'm just giving you a breathing space, 347 likes. After this question, we will see how many likes do we get. Okay. Consider the following statements. Ground for removal of political party as a national party. If a political party is not recognized in 4 or more states, does not fulfill the criteria of the national political party, it will be removed. That's how Trinamool Congress, that's how CPI, that's how Nationalist Congress Party were removed from the list of national political parties. And by providing this action, the Election Commission of India relied on the results of 2014 Lok Sabha elections, 2019 Lok Sabha elections, and close to 21 assembly elections since 2014. Clear? Consider the following statements. Question number 13. The National Security Act 1980 is a preventive detention law. Only the central government can order detention of a foreigner under the National Security Act. National Crime Records Bureau does not record data on preventive detention in India. What is the right answer? Nobody can deregister a political party. Election Commission can derecognize a political party as a national or state political party. But deregistration is not allowed. Registration of political parties is under Section 29 capital A of Representation of the People Act 1951, but there is no provision calling for deregistration of political parties. The National Security Act 1980 is a preventive detention law. This is correct. Only the central government can order detention of a foreigner under the National Security Act. This is where you might confuse yourself. Foreigner deals with foreign affairs. Foreign affairs is under the central list, which basically means that this may be right, but this is incorrect. Central government as well as the state government can order the detention of the foreigner under National Security Act. Somebody, if you will ask what is a preventive detention, I have not committed any crime, but the government may feel that I might commit a crime, and to prevent me from committing a crime, I can be booked under preventive detention laws. Clear? National Crime Records Bureau does not record data on preventive detention in India. It is incorrect because since 2017, NCRB is maintaining data on preventive detention. And if you want to know, I'll tell you a statement. Is Uttar Pradesh the leading state in terms of the number of people under preventive detention? Yes or no? Yes, maybe is not the option in UPSC. It is Madhya Pradesh, not Uttar Pradesh. That can also be a statement in your exam. But the question is asking which of these statements are incorrect. So C, 2 and 3 is incorrect. C is the right answer. Done? Great. Okay, question 14. Consider the following statements regarding crime in India. It is a report brought out by the National Crime Records Bureau. The data for the report is collected from the State Crime Records Bureau, who collects this report from the District Crime Records Bureau, and then send this data to NCRB at the end of every calendar year. Data from mega cities, and which are these mega cities? Cities having population of 10 lakh or more, is collected separately. The first edition of crime in India pertains to the year 1953. What is the right answer? This crime in India, it basically collects information on cognizable crimes. Basically collects statistical information on persons detained, crimes under which you have been detained, so on and so forth. Now, what is the right answer? Kalpana, I would leave this question. You should not. All looking correct. Sometimes apply common sense. It's a report brought out by the National Crime Records Bureau. Correct. The data for the report is collected by the State Crime Records Bureau from the District Crime Records Bureau and sent to NCRB at the end of every calendar year, because every year you need this data. Correct. Data from mega cities is collected separately. This is also correct. The first edition of Crimes in India pertains to the year 1953. D, all of the above is the right answer. Done? Let's look at question number 15. Consider the following statements regarding directive principles of state policy. These principles can only be implemented by the union legislature, union government. These principles carry political sanction. These principles are fundamental for the governance of the country. These principles are not enforceable in a court of law. What is the right answer? And again, you'll have to help me here because I do not know what is the right answer. Directive principles under Part 4 of the Constitution. Article 37 talks about two important characteristics of directive principles. Number one, these principles are not enforceable in a court of law. Nevertheless, it shall be the duty of the state. It shall be the duty of the state to implement these directive principles, because these directive principles are fundamental for the governance of the country. But what is the definition of the state? This definition is provided under Article 36 of the Constitution. And the definition of the state is same as that of Article 12, which means the state is union government, state government, union legislature, state legislature. So even the states can implement directive principles of state policy. What is the election manifesto released by the BJP in Karnataka today? One point is we will implement Uniform Civil Code in Karnataka. It's a directive principle. States can also implement this. So these principles can only be implemented by the union legislature, state government, or the union government. No, by the state legislature as well, by the state government as well. These principles carry political sanction. Correct. Sir, what is this political sanction? Dr. Ambedkar said, these directive principles, although they are not enforceable in a court of law, although they do not have legal sanction, but they have political sanction. Political sanction in the sense, if the government of the day would not implement these directive principles of state policy, would not take steps to minimize the gulf between the rich and the poor, will not take steps to enhance the living standard of the people, will not take steps to provide employment opportunities to the people, then that government shall be voted out by the people. So that's why Dr. Ambedkar said, if these principles are not enforceable in the court of law, these principles are enforceable in the court of the public. If these principles do not have legal sanction, but these principles will have political sanction. These principles are fundamental for the governance of the country. Yes, these principles are not enforceable in a court of law. Correct. 2, 3, 4. B is the right answer. Done? Great. Question number 16. The United Nations Convention on the Rights of the Child, the United Nations Convention Against Torture, the Convention relating to the status of refugee, which of the above conventions have not been ratified by India? What is the right answer? Sir, can you tell me how JPC is formed? I have a question on that. We'll discuss. Quickly, we have lots of questions to cover today. What is the right answer? Okay. United Nations Convention on the Rights of the Child, ratified by the Government of India in the year 1992. The United Nations Convention Against Torture of 1984, there have been calls that this convention should be ratified by the government. It has not been ratified. Convention relating to the status of refugees. It has also not been implemented, ratified. So 2 and 3, C is the right answer. But can you tell me about this United Nations Convention on the Status of Refugees? There is something known as this Convention of 1951 and additional protocol of 1967. What is the difference between United Nations Convention relating to the status of refugees of 51 and additional protocol of 1967? What's the difference? Okay. In 1951, it was for those displaced before 1st Jan 1951, those displaced primarily because of World War II, and those displaced those who were Europeans. So there was time constraint on 1951 convention. Only those, that means this convention would have covered only those who were displaced before 1st Jan 1951. And it had some restraint on the geographical location as well. It was applicable only for the Europeans. This additional protocol removed both these restrictions. Now, because of this additional protocol of 1967, it applies to all geographies, not necessarily Europeans. It applies at all times. So it applies not only prior to 1951 January, but it applies forever. That's the difference between the two. Okay. Question number 17, statement 1. It is a discretionary power of the governor of a state to reserve a bill passed by the state legislature for the consideration of the president if the bill endangers the position of the state high court. According to the Constitution, the term of the governor is 5 years. Which of the above statements is or are correct? What is the right answer? What are the discretionary powers of the governor? Those are not defined in the Constitution. Constitution says there shall be Council of Ministers headed by the Chief Minister to aid and advise the governor, who shall act on that advice, except when the governor has to act in his discretion. The same Constitution says what are the discretionary powers of the governor. On that, the word of the governor shall be final, which means the governor of the state gets to decide what are my discretionary powers. And whenever there is a misuse, ultimately we approach the courts. For example, something happened in Arunachal Pradesh and something happened in Punjab as well recently. Arunachal Pradesh in 2016, the Chief Minister and the Council of Ministers had advised the governor that on this particular day, some day in January, you should convene the session of the state legislature. What governor did? Governor preponed that session. Said instead of January, we will meet in December. Matter went to the court. And the court asked the governor, how can you do that? The governor said, this is my discretionary power. The court said, no, this is not the discretionary power. You have to convene the assembly session only on the advice of the Chief Minister and his Council of Ministers. And recently something else had happened in Punjab. The Chief Minister, Mr. Bhagwant Mann, and his colleagues advised the governor that you call the session of the state legislature. Governor said, you wrote me a letter and I do not like that letter. So I have to consult my legal advisors as to whether I will accept your advice or not. And what was mentioned in that letter, just a humorous story. The Chief Minister had sent some teachers for some training in Singapore. And the governor wrote him a letter. On what basis? What is the criteria that you have followed in choosing these teachers for a training in Singapore? And the Chief Minister replied and said, you tell me what is the criteria that the central government follows in choosing the governor of a state. This was not liked by the governor. The governor said, I have to take the legal advice as to whether I will accept your advice to convene the session of the legislature or not. And ultimately, matter went to the court, and the court came heavily on both the chief minister as well as the governor. Ultimately, the governor accepted the advice and called the session of the state legislature. But the moot point is, convening the session of the state legislature is not the discretionary power of the governor. So whenever there is an abuse of the discretionary powers of the governor, ultimately we have to go to the courts. But in one instance, it is mandatory for a governor to reserve a bill for the consideration of the president. Because normally governor can reserve any bill for the consideration of the president, including a money bill, including the budget. That's the discretionary power of the governor. But in one case, it is not discretionary, it is mandatory. Whenever the state legislature passes a bill which threatens or endangers the position and the status of a state high court, it is mandatory. Governor has no other option but to reserve that bill for the consideration of the president. So it is not discretionary, it is mandatory. Number two, according to the constitution, the term of the governor is 5 years. This is true. B, only 2 is the right answer. This might be confusing for a lot of students. The governor holds office. This is where we come across a doctrine known as doctrine of pleasure. The governor holds office during the pleasure of the president. As long as president is satisfied with the governor continues. So he does not enjoy, or she does not enjoy, security of tenure. Even before 5 years, she can be removed, she can be transferred, she can be asked to resign. But yes, constitution does mention that the term of the governor is 5 years. Clear? Done. Question number 18. Section 26 clause 2 of the Reserve Bank of India Act allows central government. Please read the statement carefully. This is related to the demonetization verdict given by the Honorable Court. Section 26 clause 2 of the Reserve Bank of India Act allows central government to declare any series of banknotes of any denomination illegal tender after a recommendation from the Central Board of the Reserve Bank of India. The verdict on the 2016 demonetization exercise was given by a Constitution bench of the Supreme Court. Which of these statements is or are correct? C, B, okay. Now this was the matter before the court. Demonetization exercise which was carried out in 2016, where the Prime Minister announced to the nation that from midnight 500 and 1000 denomination notes would cease to be a legal tender. The matter was before the court. Whether this should have been done by the central government, basically this proposal should have come from the Central Board of the Reserve Bank of India, or should the proposal have come from the central government and then accepted by the Reserve Bank of India? That was condition number one. That was point of contention number one. And second, can the RBI demonetize all the currency notes or any series of notes? That was the point of contention before the court. And the Supreme Court said demonetization exercise was legal. So whether this consultation was going on for 6 months between the government and the Central Board of the Reserve Bank of India. So it doesn't matter whether this proposal originated from the central bank or whether this proposal originated from the central government. So this statement is correct. And this demonetization verdict was given by a 5-judge bench of the Supreme Court. This statement is also correct. C, both is the right answer. In fact, can you tell me what is the highest denomination note ever printed by Reserve Bank of India in India? Highest denomination notes. That's why option A is incorrect. Option A is correct because section 26 clause 2 of Reserve Bank allows central government to declare any series. whether all the series, all the notes, any series of banknotes, after recommendation from the central board. And whether it is before the consultation, after the consultation, doesn't matter. If it is after the consultation, that's also okay. If it is before the consultation, even that is okay. The highest rupee note was 10,000 rupee note, which was published prior to independence of India. And it was demonetized in 1946, I guess. And then in 1978 also, it was demonetized by the Janata Party government headed by Morarji Desai. Okay, question number 19. Which of the following statements regarding the Attorney General for India is or are correct? Number 1, the Attorney General is not a public servant within the meaning of the Prevention of Corruption Act 1988. The Attorney General can speak and take part in the proceedings of the Parliament except in a joint sitting of the two houses. We have Mr. Venkat Ramani now as the new Attorney General for India. Prior to that, we had Mr. K.K. Venugopal. Prior to that, we had Mr. Mukul Rohatgi. Attorney General is in the news because of some important constitutional cases being heard by the Supreme Court. So what is the right answer? The Attorney General is appointed by the President, and that individual is appointed as the Attorney General who is qualified to be appointed as a Supreme Court judge. So you don't have to be a Supreme Court judge in order to be appointed as the Attorney General for India, but you should be qualified to be appointed as the Supreme Court judge. And that is how Attorney General, he can also take up private practice as well. And that is why he is not paid a salary, he is paid retainment. And that is decided not by the Constitution, but by the President of India. So he is not a government servant within the meaning of Prevention of Corruption Act 1988. The Attorney General can speak and take part in the proceedings of Parliament except in a joint sitting of the two houses. This is incorrect. Which of the above statements are correct? A, only one. Attorney General comes up with some of the privileges. He has the right of audience in all the courts in this country. He can come to the Parliament, speak in the Parliament, be a member of any parliamentary committee as well, can take part in the joint sitting of the Parliament as well, except he or she does not have right to vote. Why? Because you are not the member of the Parliament. But you can speak in the Parliament, you can become a member of any parliamentary committee, you can even speak at the joint sitting of the two houses of the Parliament. That is why statement 2 is incorrect. A, only one is the right answer. Okay. Let's look at another question. Which of the following statements is or are correct? Number 1, according to the Constitution, the official language of the Union is Hindi. Lots and lots of talks on Hindi imposition. Statement 2, the states can choose any language or languages as their official language, even if language is not mentioned, that language is not mentioned in the 8th schedule. A special officer for linguistic minorities is a constitutional post. What is the right answer? According to the Constitution, yes, the official language of the Union is Hindi in Devanagari script. It is according to the Official Languages Act, OLA, that English as well as Hindi is the official language of the Union. Initially, the Constitution said English will continue only for a period of 15 years from the commencement of the Constitution. After that, English will disappear. Only Hindi will be the official language of the Union. But then, because of the anti-Hindi agitation in South India, particularly in the then state of Madras, then Official Languages Act was passed, and according to that, both Hindi as well as English are the official languages of the Union, and they will continue forever and ever and ever. The states can choose any language or languages as their official language, even if the language is not mentioned in the 8th schedule of the Constitution. Yes, 8th schedule, it talks about 22 Indian languages. But the states are free to choose either one language or more such languages as the official language of a state, even if the language is not mentioned in the 8th schedule. For example, some years ago, West Bengal chose Kurk as one of their official languages, even though Kurk is not mentioned as in the 8th schedule of the Constitution. A special officer for linguistic minorities is a constitutional post. Yes. Can you tell me under which article? Article 350B of the Constitution. And it was originally not part of the Constitution. It was added via 7th Constitutional Amendment Act 1956. And basically it was added on the recommendations of the States Reorganization Commission. Because States Reorganization Commission recommended that yes, language can be the basis for reorganizing states in India. So all of the above, D is the right answer. Let's quickly look at question number 21. Which of the following statements is or are correct regarding Article 352 of the Constitution? And 352 deals with national emergency. Article 20 and 21 cannot be suspended under any circumstance. The proclamation of emergency must be approved by both houses of the Parliament within 1 month. Rajya Sabha enjoys a special power in the revocation of the national emergency. Which of these statements is or are correct? I'm waiting for an answer. Most of the students are right. Article 20 and 21 cannot be suspended under any circumstance. In fact, no fundamental right can be suspended. It is only the enforcement of that fundamental right is suspended, which means you cannot approach the court if these fundamental rights are violated. Article 19 can be, its enforcement can be suspended. All fundamental rights except 20 and 21. Proclamation of emergency must be approved by both houses of the Parliament within 1 month. This is correct. That too by special majority. Rajya Sabha enjoys a special power in the revocation of national emergency. Incorrect. 1 and 2 is the right answer. Then who enjoys a special power? Lok Sabha. Under Article 352 Clause 8. What is 352 Clause 8? If Lok Sabha is in session, then the members of Lok Sabha will have to write to the Speaker. If Lok Sabha is not in session, then the members of the Lok Sabha will have to write to a President that please convene a special session of Lok Sabha and we want to discuss national emergency. And in that special sitting, if the resolution is passed by simple majority, disapproving national emergency, then it becomes binding on the President to revoke national emergency, because this resolution is basically a statutory resolution. And we have discussed in the second class, statutory resolution is binding on the government. Clear? So it is not the special power of Rajya Sabha, it's the special power of Lok Sabha. What if Lok Sabha is dissolved? My dear, Lok Sabha is not dissolved during national emergency. In fact, the term of Lok Sabha is extended 1 year at a time during national emergency, because when it is a period of national emergency, it is not possible to organize elections, because national emergency is imposed normally in times of war or external aggression or armed rebellion. And our entire focus should be on maintaining the unity, integrity, and sovereignty of the nation. So elections can wait. In fact, the term of the Legislative Assembly, the term of the Lok Sabha is extended 1 year at a time. Okay. Question number 22. Which of the following statements is or are correct regarding a financial emergency? Financial emergency, once approved by the Parliament, can continue for a maximum period of 3 years. During financial emergency, the salaries of the holders of the constitutional posts can be reduced to their disadvantage. During financial emergency, all the money bills passed by the state legislatures are reserved for the consideration of the President. Financial emergency under Article 360 of the Constitution. If the President is satisfied that there is a danger to the credit or the financial system of this country, what the President can do, President can proclaim financial emergency. And this financial emergency should be approved by both houses of the Parliament. By what type of majority? By simple majority. That too within how many days? 2 months. So this financial emergency should be approved by both houses of the Parliament by simple majority within 2 months of its proclamation. And once it is approved by the Parliament, financial emergency continues forever and ever and ever unless and until it is revoked by the President. If you look at national emergency, it continues for 6 months. Then can be extended for another 6 months with parliamentary approval. Can be extended for another 6 months with parliamentary approval. Can be extended n number of times, but every 6 months you need parliamentary approval. When it comes to President's rule, maximum constitutional validity of a President's rule is 3 years, beyond which you cannot extend President's rule, that too under strict conditions. But when it comes to financial emergency, once it is approved by both houses of the Parliament by simple majority, within 2 months of its proclamation, it continues unless and until it is revoked by the President. So financial emergency, once approved by Parliament, can continue for a maximum period of 3 years. It is incorrect. During financial emergency, the salaries of the holders of constitutional posts can be reduced to their disadvantage. Yes, because normally we have seen, once the salary is fixed, after the appointment, you cannot reduce the salary to their disadvantage, because then you are violating their independence. But you can reduce their salary to their disadvantage only during financial emergency. That's correct. And during financial emergency, all the money bills passed by the state legislature are reserved for the consideration of the President. Can be reserved. Not are. It's not necessary. It may be possible that the central government will direct all the states that all your employees, you reduce their salary. You observe something called the canons of financial propriety. You don't travel business class, you don't stay in the 5-star hotels, you send all your money bills to us. It's not mandatory. The central government may do that, may ask all the state governments, all the state assemblies that you reserve your money bills or your budget for the consideration of the President. That's why 3 is incorrect. And what is the question asking? Which of the above statements are incorrect? So 1 and 3, B is the right answer. Done? Does anti-defection law apply during President's election? President election takes place through secret ballot. There the MPs, members of the Electoral College, they have to vote on the basis of their conscience, not on the basis of the whip issued by the political party. Consider the following statements. An electoral trust. And what is an electoral trust? You can donate money to political parties, or a political party can receive donations from multiple ways. I am setting up a political party. I will ask all the members to contribute membership fee. That's how I get money. Similarly, I can organize a rally and I can ask people to contribute and drop money in the box. That's how I can raise money for my political party, through electoral bonds. And then there is another way, through electoral trust. There are companies who are registered under the Companies Act of 1956. They can set up an electoral trust. For example, Tatas have an electoral trust. Various other companies have their electoral trust. And what is the purpose of this electoral trust? This electoral trust will receive money from various organizations, from various individuals, and with the principal objective that 95% of this donation I have to donate to political parties. That is what is known as an electoral trust. And Central Board for Direct Taxes, it is responsible for giving permission to these electoral trusts. And that's how recently 3 more electoral trusts were approved by the Central Board of Direct Taxes. Consider the following statements. An electoral trust is a trust set up by all companies with the sole objective to distribute the contributions received by it from other companies and individuals to political parties. This is incorrect. Not all companies, those companies registered under the Companies Act of 1956. Donations from one electoral trust to another is not allowed under the rules. This is correct. The electoral trusts are allowed to accept cash donations. Incorrect. Through check, through demand draft and other means, not through cash. The electoral trust can donate to all political parties registered with the Election Commission of India under Section 29A of the Representation of the People Act. Is this correct or incorrect? Is it correct, incorrect? Correct. In electoral bond scheme, electoral bonds cannot be bought to be given to those political parties which poll less than 1% of the total votes. So you can buy an electoral bond from the State Bank of India and donate this money to only those political parties which get more than 1% of the valid votes. But that is not the condition for the electoral trust. You can donate to all political parties registered under Section 29 capital A of the Representation of the People Act 1951. Which of the above statements are incorrect? 1 and 3. B is the right answer. Done? Okay. Question number 24. To register itself with the Election Commission of India, which of the following information needs to be shared by an association with the Election Commission? Election Commission plays a variety of role in India's elections. Under Article 324, superintendence, direction, conduct and control of all elections, whether President, Vice President, Lok Sabha, Rajya Sabha, State Assembly, State Council, all elections is vested with the Election Commission of India. But when it comes to urban local body elections or Panchayati Raj elections, that is the responsibility of the State Election Commission. And State Election Commission is a single member body. It is also a constitutional body. But the point is, organizing elections is not the only job of the Election Commission of India. The job of the Election Commission of India is also to recognize a party in case there is a split or merger. For example, Shiv Sena, which was started by Bala Sahab Thackeray, I think in 1966, got split. Split in the sense, there is one faction led by Mr. Uddhav Thackeray, which claims that we are the real Shiv Sena. There was another faction led by Mr. Eknath Shinde, who is right now the Chief Minister of Maharashtra. He claims that I am the real Shiv Sena. In this case, who will decide this dispute? This dispute won't go to the court. This dispute will first go to the Election Commission of India. And if you're not satisfied with the order given by Election Commission of India, then you can ask the court to review the decision taken by Election Commission. But how does Election Commission come to this conclusion as to whether it is the Thackeray faction or the Shinde faction which is the real Shiv Sena? For that, Election Commission takes a look at the constitution of that political party. Whether what is mentioned in the constitution of that political party, who is the office bearer, who is the president, who is the general secretary, so on and so forth. And the Election Commission of India performs tests of majority Who has the majority in the organization wing and in the legislative wing? Sir, what does that mean? If you have to register yourself or your party with the Election Commission of India, you also have to share the constitution. Or whenever you are updating, amending your constitution, share the updated copy with the Election Commission of India. So that tomorrow, if there is a split, or if there are two factions claiming your political party, the Election Commission of India will perform the majority test and will look at organizationally who has the majority. All those who are the office bearers, the president, the vice president, the general secretary, the district presidents, we will ask them, we will see who is supporting which faction, and there what is the majority. And then we will look at the majority in the legislative wing. This political party will have its MPs in Lok Sabha, Rajya Sabha, MLAs and MLCs, and we will see who has the majority, whether the Shinde faction or the Thackeray faction. And then Election Commission will decide who is the real Shiv Sena. In the Shiv Sena case, the Election Commission decided that Mr. Shinde's faction is the real Shiv Sena only by looking at the legislative wing majority, not the organization wing majority. Why? Because the Election Commission said that in 2018, Shiv Sena had amended its constitution, and the updated copy of that amendment is not shared with the Election Commission of India. So we cannot test in the organization wing which faction has the majority. That is why we will rely only on the majority in the legislative wing. And by analyzing the majority in the legislative wing, we come to the conclusion that Shinde faction is the real Shiv Sena. So the arrow and the bow, the symbol of the Shiv Sena, will be given to the Shinde faction. Clear? Now look at the question. To register itself with the Election Commission of India, which of the following information needs to be shared by an association with the Election Commission? Number one, name of the party, which should not contain religion or caste. The membership should be open to all the citizens. Constitution as well as the criteria to be followed for amending that constitution. Merger, split and dissolution procedure. What is the right answer? Sir, please refer to AIADMK crisis in Tamil Nadu, since the claim went to the court and not to EC. It first went to EC, then went to the court. Who gets the two leaves symbol of AIADMK? Because initially there was a split between Mr. Palaniswamy and Mr. Paneerselvam, as well as Ms. Sasikala. Then Mr. Paneerselvam and Palaniswamy, they got together and they got the two leaves symbol. Name of the party should not contain religion or caste. This is correct. Membership should be open to all citizens. Incorrect. Membership should be open to all the adult citizens. Constitution as well as the criteria to be followed for amendment, merger, split and dissolution procedure. 1, 3, 4, B is the right answer. Okay, great. Let's look at question number 25. Somebody asked this question before. A joint parliamentary committee, because there is a lot of debate that a JPC should be constituted to look into the Adani issue. But now there is an investigation by the SEBI. But be that as it may, a joint parliamentary committee can only be created based on a motion passed by one house of the parliament and agreed to by the other house. The strength of the JPC has to be 30 members with 20 from Lok Sabha and 10 from Rajya Sabha. A JPC is always headed by a member of the opposition. Which of the statements given above is or are correct? What is the right answer? I'll give you 1 minute. How can a JPC, Joint Parliamentary Committee, be constituted? There are two ways. One is that one house, let's say Lok Sabha, will pass a resolution by simple majority, and then Rajya Sabha will approve this resolution by simple majority. Both sides, both houses have agreed, a joint parliamentary committee will be set up. There is another way. Instead of resolution being passed by both houses of the parliament, the presiding officers will write to each other. The Speaker of the Lok Sabha will write to the Chairperson of Rajya Sabha, or the Chairperson of Rajya Sabha will write to the Speaker. Let's constitute a JPC. This is also another way by which a JPC can be constituted. So a JPC can only be created based on a motion passed by one house and agreed to by the other house is incorrect, because it can also be created when presiding officers write to each other. Clear? The strength of the JPC has to be 20 members, with 20 from Lok Sabha, 10 from Rajya Sabha. Incorrect. This motion will decide the strength. The motion which creates a JPC will decide how many members will be part of the JPC. For example, in 2001, when a JPC on stock market scam was set up, there were 30 members of JPC. 20 were from Lok Sabha, 10 were from Rajya Sabha. But then when a JPC was constituted on the presence of pesticides in soft drinks in India in 2003, I guess, there were 15 members in JPC. 10 were from Lok Sabha, 5 were from Rajya Sabha. So it is the motion which creates a JPC that determines what is the strength of the JPC. Here the statement says the strength has to be. It makes it clear that this is going to be the strength forever. No, the motion which creates a JPC decides its strength. A JPC is always headed by the member of the opposition. This is also incorrect. There have been JPCs headed by the members of the ruling party. So which of the statements given above are correct? None of the statements are correct. How are we supposed to know this? By reading, by revising, or by following BYJU'S Exam Prep. If JPC is created by presiding officers, they will specify what should be the number of the members of the JPC. Okay. Consider the following pairs. Bachchan Singh case, and you will have to select which of the pairs are correctly matched. Bachchan Singh is related to death sentencing. Arnesh Kumar is related to bail. Skara versus Union of India is related to judicial appointments. Let me know what is the right answer. There is no minimum or maximum number of JPC members. It depends upon the motion which creates a JPC. Bachchan Singh case is related to death sentencing, yes, because this was the case in which the Supreme Court innovated rarest of the rare doctrine. 1982, when the Supreme Court said mandatory death sentence is unconstitutional. In a sense, you can't say that for this particular offense, mandatorily you have to award capital punishment, death sentence. No. Death sentence can be awarded only in the rarest of the rare cases. And now this rarest of the rare doctrine is also being reviewed by the Supreme Court. We'll have to wait and watch what happens in that case. That's why this topic becomes important. Arnesh Kumar is related to bail, where the Supreme Court said, yes, for an offense for which the punishment is less than 7 years, consider bail, don't consider jail. Skara versus Union of India, yes, this is the second judge's case where Supreme Court invented the collegium system of judicial appointments. All the three pairs are correct. C is the right answer. Moninder Singh case was also on the rarest of rare case. In Moninder Singh case, rarest of the rare doctrine was applied, where Moninder Singh, where the case was first heard by the Punjab and Haryana High Court, where this individual initially had raped his daughter, then he was out on parole, then killed his daughter as well as the wife. Then the Punjab High Court said this is the rarest of the rare case, give death sentence to Moninder Singh. But he went to Supreme Court. Supreme Court said no, this is not the rarest of the rare. So rarest of the rare doctrine was not innovated by the Supreme Court in Moninder Singh case. It was applied there. Okay, great. What is the difference between motion and resolution? Motion is the opinion of the House. Resolution is the resolve of the House. All the resolutions are voted upon. All motions may not be voted upon. Consider the following statements. Without the Attorney General for India's consent, no criminal contempt proceedings can be initiated in the Supreme Court. The maximum sentence in a criminal contempt case is an imprisonment for 2 years. Which of the statements given above is or are correct? Tell me. Waiting for the answer. Contempt is of two types. Either it is civil or it is criminal. What is civil contempt? Willful disobedience of a court order. For example, the court asked me to be present tomorrow. I said, okay, I will attend, but I'm not attending. I'm not appearing before the court. What I'm doing, I'm willfully disobeying a court order. This is civil contempt. But criminal contempt is dangerous, where you are scandalizing the court, or you tend to scandalize the court, or attribute motives to the court. This judgment was given by the court because the judges have taken money. This judgment was given by the court because the judges and the executive, they are hand in glove with each other. They have taken money, blah, blah, blah. This judgment was given by the court because this judge belonged to a particular caste. That is criminal contempt, and criminal contempt is taken seriously by the judiciary. The maximum punishment for a criminal contempt is not 2 years, it's 6 months, or fine, or both. Prashant Bhushan was convicted for criminal contempt, but instead of punishment for 6 months, he was awarded a fine of 1 rupee. Why? Because the then Attorney General, Mr. K.K. Venugopal, said, please have mercy on Mr. Prashant Bhushan because he has worked a lot for the downtrodden, weaker sections of the society. He has filed a lot of personal public interest litigations to help the needy of our society. But be that as it may, statement number 2, the maximum sentence in a criminal contempt is an imprisonment for 2 years, is incorrect. But how can you file a criminal contempt case in the Supreme Court? There are 3 ways. One is Supreme Court suo motu. On its own, the Supreme Court will read a newspaper article which is critical of the Supreme Court, which scandalizes the Supreme Court, or a statement given by somebody which scandalizes the Supreme Court. On its own, the Supreme Court will initiate criminal contempt proceedings against that individual. That's number 1. Number 2, second way, Attorney General for India files this case. Attorney General himself or herself approaches the Supreme Court and files a criminal contempt case against somebody. There is a third way. Any third person. And who is this third person? First person is either the Supreme Court itself. Second person is either the Attorney General for India or any third person. You can approach the Supreme Court and file a criminal contempt case against me. But for that, first you have to take the consent of Attorney General for India. Why? This permission is required to save the time of the court. So only in the third way, without Attorney General's consent, no criminal contempt proceedings can be initiated in the Supreme Court. No, Supreme Court can suo motu, on its own, initiate criminal contempt proceedings against somebody. That is why this statement is also incorrect. Which of the statements given above are correct? D, none. D is the right answer. When can the President promulgate an ordinance? The President can promulgate an ordinance when either one or both houses of the Parliament are not in session. And President can promulgate ordinance on all subjects on which the Parliament has the power to make a law. But an ordinance cannot be promulgated to amend the Constitution. Question number 28. Which of the following statements is or are correct regarding Article 366 of the Constitution? Anglo-Indians, their reservation in Lok Sabha and legislative assemblies was snatched because of 104th Constitutional Amendment Act. Is this term Anglo-Indian defined anywhere in the Constitution? Yes. Where? Article 366 of the Constitution. What Article 366 talks about? It contains definitions of various terms which are used in different provisions of the Constitution. For example, who is an Anglo-Indian? What is the definition of agricultural income? What is the definition of the corporate tax? Who is a scheduled caste? Who is a scheduled tribe? Something mentioned in Article 341 of the Constitution. All these definitions are provided under Article 366. And who is an Anglo-Indian? It defines Anglo-Indian as a person, listen to me carefully, whose father or any of whose other male progenitors, descendants, in the male line is or was of European descent, but who is now domiciled within the territory of India. Such an individual becomes an Anglo-Indian. Only from the father's side, only from the male side, not from the female side. Sounds slightly sexist, but that is how it is. So C is correct. C, both 1 and 2 is the right answer. Question number 29. Which of the following statements regarding Press Council of India is or are correct? The chairperson is nominated by a committee consisting of the chairman of Rajya Sabha, the Speaker of the Lok Sabha, and a person elected by the members of the Press Council. The council shall consist of chairperson and 28 other members. Why Press Council of India is in news? Because Justice Ranjana Desai is the chairperson of Press Council of India, has been appointed as the chairperson of the Press Council of India. And who is Justice Ranjana Desai? Ex-judge of the Supreme Court, but that is not important. But what is important? She was the chairperson of the Delimitation Commission, which carried out delimitation exercise in the Union Territory of Jammu and Kashmir. So the chairperson is nominated by a committee consisting of the chairman of Rajya Sabha, the Speaker of the Lok Sabha, and a person elected by the members of the Press Council. This is correct. The council shall consist of a chairperson and 28 other members. This is also correct. Both is the right answer. In fact, there are some members in this Press Council. What is Press Council basically? It's basically self-regulation of the print of the newspapers, broadcasters. Some of the members, 28 members, they are the editors of newspapers. Some of them are the publishers of the newspapers. Some of them are the other journalists. And there are also 5 members of parliament. This is a very, very important detail, can be relevant for your exam. 5 members of the parliament, they are also members of the Press Council of India. But who are these 5 members? 3 from Lok Sabha, nominated by the Speaker of Lok Sabha. 2 from Rajya Sabha. Nominated by the chairperson. What is the right answer? C, both 1 and 2 is the right answer. Let's look at question number 30. Which of the following statements regarding the Model Code of Conduct is or are correct? The party or candidate shall inform the local police authorities of the venue and time of any proposed meeting well in time, so as to enable the police to make necessary arrangements for controlling traffic and maintaining peace and order. This sounds correct, Logical, but is it part of the model code of conduct? That you will have to tell me. The model code of conduct ends when the last voter has cast his or her vote. Opinion polls cannot be published or broadcast during the model code of conduct. Which of these options are correct? Let me know what is the right answer. All seem correct. A, D, okay. The party or candidates shall inform the local police authorities of the venue and time of any proposed meeting well in advance so as to enable the police to make necessary arrangements for controlling traffic and maintaining peace and order. This is correct. This is part of the model code of conduct. Model code of conduct ends when the last voter cast his or her vote. Incorrect. Model code of conduct ends with the declaration of results. Opinion polls cannot be published or broadcast during the model code of conduct. Incorrect. They can be. A, only one is the right answer. Opinion polls can be published or broadcast during model code of conduct? Yes. How? Let me explain. Model code of conduct starts when? When the date is announced by the Election Commission of India. This is where the model code of conduct starts. And model code of conduct ends with the declaration of results. During this period, are you saying opinion polls cannot be published and broadcast? This is wrong. Opinion polls are published. Even today an opinion poll was published. Yesterday an opinion poll on Karnataka elections was published. Opinion polls cannot be published during the period of election silence. And what is this period of election silence? 48 hours before the end of polling. Let's say model code of conduct in Karnataka began when the dates were announced. Can opinion polls be published? Yes, 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 yes. But now there is voting. Today the voting starts. It will end at 6 p.m. for example. From 6 p.m. backwards, calculate 48 hours. That is the period of election silence. And during this period of election silence, no campaigning can take place, no canvassing for votes can take place, no opinion polls can be published or broadcast. So there is only one limitation. Opinion polls cannot be published, broadcast during the period of election silence, but can be broadcast during model code of conduct. Clear? But what about exit polls? Opinion polls cannot be published or broadcast during model code of conduct. Exit polls and post polls can be published only after the last person has cast his or her vote, when the entire voting has ended. That is the limitation on the exit poll or the post poll. And that was about it. Polity, Indian polity based questions. We have discussed 30 questions today, the maximum we have discussed over the past 4 days. Thank you so much for being with me. If these lectures have been of some help to you, do let me know in the comment section today after you have pressed the like button. But whatever questions you have, please let me know. I'll be more than happy to answer. Ordinance can be issued in case of money bill? Yes. Parole is at the discretion, furlough is the right of the prisoner. Okay, there is nothing apart from thank you. So thank you. Whatever doubts you have, drop in your comments. I will respond to all your doubts. And thank you so much for staying with me. Good night. Stay safe. Stay best. All the best. This is just like any other exam. Don't take it too seriously. Don't take it too lightly either. My best wishes to all of you. May all your legitimate dreams come true. Good night.